the standard needs to be strictly managed. And so I certainly appreciate those concerns. I think I've noted that in the past. So I also would support the argument, the suggestion that this is not a standard that we're setting going forward. Other parties that come forward requesting a waiver, if anything, it'll probably be more difficult for you to make sure that they've met this standard.
Thank you, Commissioner. Of course, it goes without saying that each of these waiver requests will be reviewed and adjudicated based on its merits and the factors and circumstances involved in each case. With that, I will propose a motion that we grant the company's request for a waiver of COMAR Title 20, Subtitle 62, Chapter 3, Regulation 8A as in alpha, to allow the co-location of two 2-megawatt low or moderate income community solar projects for good cause pursuant to COMAR 20.62.3.8E as an echo. The vote begins with Commissioner Linton.
Aye.
Commissioner O'Donnell.
Mr. Chairman, I'm going to explain my vote. So before I can explain my vote, I have to vote. I'm going to vote no. And in explaining my vote, I think there is merit here to Mr. Buellman's response with regard to distinguishing characteristics in terms of providing LMI CSEGs in the PE service territory has merit. I'm not acknowledging that. However, in probably a feeble attempt to memorialize my concerns with regard to not setting a low bar precedent future waiver requests, I'm going to vote no and attempt to try to at least get that into the record so that we're not setting such a low bar that we have to approve all of these going forward unless we bend over backwards to show why. So, vote no.
Commissioner Richard. Aye. And I vote aye. The motion is approved. Thank you.
Mr. Chairman, item number 5 is a proposal from Columbia Gas of Maryland, Inc. to update its WarmWise low-income usage reduction program and revised energy efficiency rider.
Good morning.
Mr. Chairman and Commissioners, Kate Shaw on behalf of staff. On April 22nd, 2022, Columbia filed its proposal to update its WarmWise low-income reduction program and provide EE rider effective June 2022 through May 2023. The proposed EE rider surcharge in the filing will replace the existing surcharge effective May 31st, 2022. Columbia is proposing an EE rider of 0.00155 cents per therm, which is a 0.0147 monthly bill decrease compared to last year. The company is also forecasting it will be able to weatherize around 16 homes for the upcoming program. Staff has reviewed the filing and finds the company's proposed EE rider is reasonable and prudent and concludes that the rates were calculated correctly. Staff recommends the Commission approve Columbia's WarmWise low-income usage reduction program, so provide Columbia's revised EE rider effective May 31st, 2022. And staff is available for questions.
Thank you, Ms. Shaw. We'll turn to the company.
Morning, Mr. Chairman and members of the Commission. Neil Tupari with DLA Piper on behalf of Columbia Gas today. Here with me as well is Tammy Lynn Revere, the company's Community Outreach Education Coordinator. I have nothing to add to Ms. Shaw's recitation of the application and recommendation, and we're available for questions as well.
Thank you. Just to be clear, the budget is about $90,000. Is that correct?
That's correct.
And how many homes?
For this particular upcoming year, the weatherization would be for 16 homes, Mr. Chairman.
Thank you. And how does that compare to last year?
We strove for that last year.
Mr. Chairman, I don't have an exact number. I believe that the 16 home goal was the same last year as it is this year. But I'm happy to supplement that information for the Commission.
That's not necessary. We can find that here. Although this results in a rate decrease.
Right, and that was, I thought, particularly positive for the upcoming year, just based on the development of the program.
Okay, thank you. Questions from my colleagues? Seeing none, I would move that we approve Columbia Gas of Maryland's WarmWise low-income usage reduction program and accept the revised tariff pages for filing with an effective date of May 31st, 2022. The vote begins with Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard? Aye. I vote aye, the motion is approved.
Thank you very much, Mr. Chairman.
Thank you.
Item number 6 is an update from US Wind Inc. to its estimated project commercial operation date in case number 9628.
Good morning to staff.
Good morning, Mr. Chairman, Commissioner. First below on behalf of staff. On April 13, 2022, U.S. Wind filed a letter to the Commission to update its estimated project commercial operation date for its project Marvin. It was awarded offshore wind renewable energy credits on May 17, 2017, in order number 88192. On May 16, 2022, the Office of the People's Counsel filed comments and recommendation, ballot number 240703, regarding this filing. Pursuant to Comar 20.61.06.16G, if the new estimated project COD will not occur before the end of 5 years after the original estimated project COD, or if the Bureau of Ocean Energy Management BOEM terminate its offshore wind project lease, the Commission may revoke the OREC order or any OREC pricing schedule previously issued to the project, and adjust the offshore wind energy RPS and OREC purchase application under Section C of this regulation. US Wind's original OREC application included an estimated COD of 2021. That date has been changed in several filings as the project progresses. The current estimated date for the project is now projected to be December 2026, more than 5 years beyond the original date. In the filing, US Wind explained that the COD change related to a number of factors which has led to delay, including the global supply chain issues, federal permitting delays, ongoing backlogs with PJM interconnection queue, and also timing of the system upgrades for the project. Many of these factors are impacting the project advancements. As discussed in staff comments, US Wind has demonstrated good faith effort that the company has diligently pursued and engaged in continuous development program for the project since the application was ready in 2017. Based on its reviews of the record and discovery responses, staff concludes that by declining to exercise Commission discretion to revoke the OREC order pursuant to Comar 20.61.06.16G, as a result of the COD change, US Wind will be able to continue advancing project developments and construction activities. Staff recommends that the Commission decline to exercise discretion to revoke the OREC order at this time, pursuant to Comar 20.61.06.16G, as a result of the US Wind's new estimated COD for the project, and accept the updated OREC price schedule in the filing. Thank you very much.
Thank you, Mr. Love. We'll next hear from Office of People's Counsel. Mr. Fields, it appears that you have a primary argument and an alternative argument. If you could brief those.
Yes, sir. Morning, Commissioners, Chairman and Commissioners, William Fields for the Office of People's Counsel. It's good to see you. We did file comments on this on Monday. Our basic recommendation is that the Commission require the creation of more of a record before making the decision on this request for a declaration. And we request that for 3 reasons. First, this is an important decision to make. The point of the law is for projects to actually be built and achieve the environmental and economic benefits of the projects. And the record is currently a single DR response from US Wind and staff's analysis, some of which is based on information that's not before the Commission at this point in time. Mr. Lowe just mentioned that the company explained some things in the filing. They explained it, as far as I can tell, in a data response that's attached to the to the staff's buck sheet. And really, the basis of our recommendation is that there should be a record created of testimony, of evidentiary material, documents, and testimony directly to the Commission explaining where we are with this project. The regulation that giving the Commission this authority to change or cancel the OREC schedule is really the only oversight point that the state has for managing the development of this project, which, as was pointed out, it's quite delayed. And I'll point out that in the Comar regs, Section G simply gives the commission discretion once the project delay goes past 5 years. Gives the commission discretion to revoke the OREC order or any price schedule. The H is a separate section that talks about withdrawing the order if they're unable to obtain rights to a loan lease or bankruptcy or demonstration of diligent pursuit. That's a separate provision which I read to be applicable at any time. The section G gives the commission discretion independently once the project has been delayed more than 5 years. Our second point is that the situation with this project has changed quickly and significantly. We had hearings in November, and that resulted in the order for the second U.S. wind project, Momentum Wind. And at that point, the discussion was about developing the two projects sequentially. First project first, and then the second project. And now we're talking about projects coming online at the same time. The commission should get an explanation for why that change has occurred and what it means for the development of the first project, particularly if there are subsequent delays to the second project. And that that explanation should come directly from the company and be on the record. Third, it is quite possible that there will be another change in the COD for the project in the future. And for the commission to judge whether to make changes to the OREC schedule based on some future request, creating a full record now will be valuable in reviewing that future request. So those are the basis of our recommendation. As the chairman noted, we do have an alternative. If the commission is inclined to make the declaration that the company has asked for, our alternative recommendation is that the commission condition its declaration on one, U.S. Wind making a detailed plan with milestones for achieving the revised COD, and two, a commitment that should the company seek to change the COD again, that it would make an evidentiary filing at that point, including testimony to describe the progress of the project and discuss whether the commission should retain the original OREC schedule. Thank you, Your Honor. Those are our recommendations. I'd be happy to answer questions.
Thank you, counsel. We'll hear next from the developer, and then we may have questions for you.
Thank you, Your Honor. Nice to see you again. Commissioners, nice to see you again in a few months. Tom Previs on behalf of U.S. Wind. I'm joined by U.S. Wind Country Manager and General Counsel Salvo Vitale. We thank the staff for its good questions that they asked to us, and we provided 8 pages of answers and a project schedule and response. We agree with the staff's conclusions and recommendations, which are twofold. One, that the commission provide us guidance that they will not revoke based on the new schedule, and second, that the commission accept the revised OREC schedule that we filed with our document as the applicable one to provide certainty. With that, we believe that our responses in almost every case address directly some of the concerns of People's Counsel, and that in any event, the OREC conditions that are appended to both orders have us reporting in a very regular basis and providing the commission with a great deal of detail about the project and schedule timeline of our project, and that we have a forum already for continuing to update the commission about our concerns. So with that, I thank the commission for its time. I thank staff and People's Counsel, and we're available for questions.
Thank you, Mr. Previs. You are correct. There is a tremendous amount of reporting by our two wind developers. We receive updates on a regular basis in the docket. I do also recognize the concerns that Mr. Fields raised with respect to the fact that this is a very important decision, at least from their perspective, and I'll allow Mr. Fields to respond. It doesn't feel like they are aware of all the necessary milestones and updates. But to be clear, you are filing this in your case docket before the PSC, correct?
That's correct.
You heard from Mr. Fields a moment ago. He had his primary argument, and then he had an alternative argument if the commission were to move forward today with the declaration not to exercise discretion. And is it fair to say that it's your financiers that are pushing this filing that's before us today?
That's correct, Your Honor. And the various stakeholders that wish to have certainty over the project, which is in fact the purpose of the OREC order, I think, as well.
And I think if we all, that this was a better world and a better process between the state and the feds and the supply chain, we wouldn't have to worry about a deadline 5 years now. Mr. Fields, in addition to his primary argument, had an alternative argument with two requests of the commission, if the commission were so inclined to move forward. And that is that you'd file a plan within 30 days with milestone completion dates. And number two, that you simply provide a commitment that should there be additional changes, and likely that there will be changes and delays in the future if history is any guide, that you would submit that documentation before the commission. How do you respond to his alternative argument?
Thank you for the opportunity, Your Honor. With respect to the first part of the alternative argument, we provided a project schedule as attachment A to the staff's request, and we believe that adequately sets forth the schedule that we would be following in terms of getting to our COD and providing sufficient contingency in case we, certain things are not going to be able to be predicted on a perfect schedule. And so we believe that does provide the commission with sufficient sufficient record as to what we intend to do. And we will, of course, be continuing to update the commission. And so our view is that no additional information is required. Of course, anytime the commission requests anything of us, we tend to try and provide it. And so that is, of course, up to the commission. It's something we would do, but it would not be our first choice. Yes.
So if I'm hearing you correctly, your attachment A would satisfy Mr. Fields' first prong, the filing that he wished to receive in 30 days. And with respect to B, the commitment, are you basically saying that US Wind is providing that a commitment?
With respect to B, it sounded like what Mr. Fields was saying was that in any future instance in which the COD needed to change, we would commit to having a full, I guess, evidentiary hearing or something. That's the way I heard it. I see that as perspective, even more perspective than our request at this time. Actually, frankly, I don't think our request about revocation is perspective at all. We're changing the date and we want to know that it's not going to be revoked. I think that's up to the commission in the future, frankly. And we're going to do whatever the commission requires of us, as we are doing now and as we would do if we ever even need another change. We would do that. Of course, we're going to provide whatever information is asked of us.
Let me provide Mr. Fields with an opportunity. If you'd like to take a seat at the table.
Me as well? Or Jack?
You can take the podium. I was thinking you'd come to the table, but Mr. Previs, you and
okay.
Mr.
Didn't
Powell
understand.
may sit at the table.
Okay.
So we have microphones for everybody.
Thank you, Your Honor. Appreciate the opportunity. And perhaps we were, there's a little bit of talking past each other at some point here. We are aware of the 7 pages of data responses that the company provided to staff. And they include a chart with milestone, which looks like very could be useful information going forward. Part of our concern is that this is not, as far as we could tell, it's not attached to the commission, to the staff tough sheet, and it's not officially in the record before the commission. It was
Mr. Fields, do you have the 7 pages?
Yeah, right here.
You do. Okay. Just to be clear.
Yeah. And so that's part of our concern, is that is not before the commission. It's not in the docket. It's not on the commission's website that this document is out there. And I think you also were looking for a response from me on
The second item, as Mr. Previs mentioned, that it does seem as if you're requiring that the commission to pre-commit to having some type of evidentiary proceeding with testimony, with evidence every time there's some type of a schedule change or?
Yes, that is the alternative recommendation, certainly the next time. And we think it would be appropriate and useful for the commission to hear directly from a company witness, again, in an evidentiary proceeding where there's pre-filed testimony, ability for parties to ask some questions, and then get the explanation directly from the commission. I'm sorry, directly from the company to the commission on the record.
If that were to occur, though, they would have to come back again. You'd have another argument to argue that we should have some type of evidentiary proceeding. Do we need to make that decision today? If their projections change again, and let's assume they will.
Yeah, I can't say that you need to make it today, but it would depend on the process going forward if the company was aware that that was going to be the case the next time they have to change the COD.
Okay, well, I appreciate that, and I think you've put the company on notice that perhaps the next time they come in, the commission, well, we reserve that right, whether we do it today or we do it 6 months from now at the next juncture. Mr. Priebus, Mr. Fields makes a good point. The 7 pages that you supplied to staff, that's not formally before us today. It was correspondence to staff. Would it be much trouble to satisfy Mr. Fields by effectively making that his 30-day compliance filing that he's requesting? Have that memorialized, whether you modify the 7 pages or you just file it with the commission this afternoon. It does have completion dates. It does have some blanks as well because you don't know what the completion dates are. Any harm or foul of putting that on the record?
We have no problem with the information being posted on the website, with us formally filing it. The only thing that we would ask, we are seeking a decision, and 30 days is impactful to us, in terms of,
Well, you may get a decision today. I don't think Mr. Fields was making decision contingent on. I think he wants the detailed plans, but maybe I'll let Mr. Fields. Mr. Fields, are you saying we delay our decision until you have a chance to review that document?
Well, in the, our primary recommendation would be that way, Your Honor. Our alternative would be, if you're inclined to move forward today, that you require that they make this filing within 30 days.
That's how I read your pleading, Mr. Fields. So, Mr. Priebus, does that allay your concerns?
that does, yes, if we could have a decision today, we'd be more than happy to file it even this afternoon or when we get up from the chair here, for that matter.
Thank you. These are big projects. They're expensive projects. I hope to see the blades spinning at some point in the, I would say near future, but it could be further off. I'll turn to my colleagues for any questions. Commissioner Richard.
Yes, I think you've pretty much covered it very well, so I'm not going to really go into a lot of questioning. But I did want to note that I took very seriously the filing by the People's Council, and I think they raised a lot of important issues. These are vital projects to our state's policy, to our initiatives to address climate change, and the impacts we know that are going to happen to our state. So it's time is of the essence. So I think that we've accomplished today. I would also note that we did go from the first round, a annual filing to quarterly filings, again, just to make sure that we did have that type of information necessary to ascertain whether or not our developers are in fact moving with all speed possible. So that's important to me as well. And also I would note that the companies, both developers, have been very forthcoming with information. So I've been quite satisfied that, in fact, I think both companies are moving as quickly as they possibly can at this point. And hopefully with some support from the federal government, we can even accelerate that. So again, I'm very satisfied with, I think, the exchange we've had today, and also with, I know, the motion that the chairman's about to offer. So with that, I have no questions. Thank you.
Mr. O'Donnell.
Thank you, Mr. Chairman. Mr. Lowe, I wanted to ask you just to make sure I understand. The plug sheet talks about changing the OREC price schedule, correct? So I understand that has to change. What impact does that have on the OREC price?
Well, basically, because the COD days goes beyond the original date. So basically, they added one more price at the end of the schedule.
I'm sorry, I can't hear you.
I'm sorry. The price schedule basically is, because the COD is that's going beyond the original 5 years. Oh, so the price added one more number at the end of the schedule. So basically, it's not changed.
So the dollar value of the OREC is what I'm asking about. Does that change?
No, basically, it's still 1% of the escalator still there.
Okay, there is a 1% change, right?
Just like the original,
Right.
one.
But the longer, my point is this, the longer that these things extend, the higher these OREC values become. They just continue to escalate.
Right. I don't have the answer for that. So
I think they do with 1%, right? Annual per annum. So I just wanted to point out there's an incentive here. I mean, we're in times of high volatility in our economy. Inflation is through the roof. I wouldn't be surprised at some point to see these developers come back and say, we can't do this unless you give us a large OREC increase. Because the value of these ORECs is being diminished, even with a 1% escalator over time. And I just want to point that out for the record, that we're cognizant of it, that it's potentially a problem going forward the longer these things are delayed, because notwithstanding the fact that I don't believe this inflationary period is transitory at all, contrary to public statements otherwise, it's going to be with us for a while. The longer it stays with us, the more pressure is going to be to increase these OREC prices. So, thank you, Mr. Chairman. I just want to make that clear.
Thank you. Seeing nothing further, at this point, I will move that we, number one, note US Wind's April 13th, 2022 update to its project COD and OREC price schedule. Motion number two, move that we decline to exercise the Commission's discretion under COMAR Title 20, Subtitle 61, Chapter 6, Regulation 16, G as in golf, to revoke the ORECs granted to US Wind in Commission Order number 88192, provided that US Wind diligently pursues and engages in a continuous development program to achieve project COD. This is conditioned based on a partial granting of OPC's request that US Wind make a filing, that filing be a plan with milestone completion dates for achieving the revised COD within 30 days or sooner, if you'd like to file tonight. And finally, we accept the updates to the OREC price schedule contained in US Wind's filing dated April 13th, 2022. The vote begins with Commissioner Clinton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. Just to be clear, Mr. Previs, did you understand the motion that was just granted?
I did understand, and we will file this afternoon.
Or within 30 days?
No sense waiting.
No sense waiting. To the extent you need to make changes, updates, revisions to that filing, since it was filed a week or so ago, please take that opportunity. All right, we have nothing else on today's docket, so this meeting is now adjourned. Thank you.
You're up.
Thank you.